Yes, Judge, I'm here. Hopefully my video will be better. I'm in the office today, so hopefully there's no lag.
Oh, you mean the sync? We've had
The sync, yes.
difficulties. So you're here, Mr. Calhoun's here. I think we have everybody that we had the last time. Are we good to go, counsel?
We are good to go, Your Honor. I don't know if WCC hearings, I think you have to unmute them when you're ready for them to speak.
Let's ask. Mr. Middlestat, talk to me. Can you hear? Can you respond? No, hold on. Let's get.
We can't hear you, Mike. We can't hear you.
All right, we sent a request for you to unmute yourself.
Yeah, but I don't think.
Hold on. There's a second delay. Try again, Mr. Middlestat. There you go. I think that's it. Yep, you got it.
Okay, great. Thank you, Judge.
All right, Williams, let's make sure. Let's do a test with you. You're good, Mr. Williams?
Yes, Your Honor.
Judge, can Mr. Middlestat turn his volume up like Mr. Williams did?
I don't know. Mr. Middlestat, my stenographer is asking if you could raise your volume.
Is that better?
Probably not, but
Okay.
I think it's okay. It's loud enough for everyone. Okay. Good to go.
The court is calling case 06-013904 and case 06-013905 in the matters of the people of the state of Michigan versus Terrence Calhoun here today for motion hearing. Appearances for the record, please.
Prosecution.
Good afternoon, Your Honor. Valerie Newman, Deputy Chief and Director of the Conviction Integrity Unit for the Wayne County Prosecutor's Office.
Thank you. Mr. Middlestat.
Good afternoon, Your Honor. Mike Middlestat of the State Appellate Defender's Office, appearing on behalf of Mr. Calhoun, who is seated to my right.
Okay, Mr. Calhoun, tell me your name, please.
Terrence Terrell Calhoun.
Thank you, Mr. Calhoun. To Mr. Calhoun's right, could I have your name, please?
Yes, Tabitha Harris, Special Assistant Defender from the State Appellate Defender's Office, with and on behalf of Mr. Calhoun, who's to my left.
All right, thank you. And sir, your name.
David Williams, Staff Attorney at the WMU Cooley Innocence Project.
Okay, thank you. Mr. Calhoun, I did this the last time. I'm going to ask you the same question this time after putting you under oath. Mr. Calhoun, would you kindly raise your right arm for an oath? Mr. Calhoun, do you solemnly swear to tell the whole truth, nothing but the truth, so help you God?
Yes.
All right, Mr. Calhoun, we are conducting this hearing. You can put your hand back down now. We're conducting this hearing on Zoom technology. Is that okay with you?
Yes.
All right, fair enough. All right, counsel, obviously, we were all here last week and the court directed the prosecution to review the evidence and or information that an officer wished to convey to this court. Based on the fact that neither the prosecution nor the defense have sought an adjournment of today's hearing, I am assuming that it is safe to conclude that the people intend to move forward with the motion and request today. Is that correct, Ms. Newman?
That is correct, Your Honor.
All right, Ms. Newman, did the officer provide the prosecution with any additional evidence and or information that was not previously known or considered in the investigation?
The officer did not, Your Honor.
Okay. And Ms. Newman, the court received today from via email an updated stipulated finding of fact and an agreed upon order to vacate the conviction and dismiss the cases with prejudice. Confirm?
Confirm, Your Honor.
Okay. Obviously, Ms. Newman, and to all parties, this case has received a lot of attention and merits that we dot all of our dots and cross all of our T's. And at this time, Ms. Newman, I would like to ask that the prosecution to articulate for the record the findings that support the people's decision to vacate Mr. Calhoun's convictions and sentence. And I'm assuming that you're going to read from the stipulated findings of fact and agreed order to vacate the convictions and dismiss the case with prejudice. Ms. Newman.
I can do that, Your Honor, no problem. So I'll do that first, and then I just had a few other additional things to add to it. So the document presented to the court is stipulated findings of fact and agreed order to vacate convictions and dismiss cases with prejudice. It reads as follows. The parties in this matter agree and stipulate to the following. 1, on September 26, 2006, victim 1, age 15, was grabbed and assaulted by a man near Fenkell Avenue and Blackstone Street in Detroit, Michigan. No physical evidence was reportedly recovered from the scene. 2, victim 1 described her assailant in part as having braids and a puzzle tattoo on his arm. 3, on October 27th, 2006, a man sexually assaulted victim 2, age 13, at gunpoint in an alley near Fenkell Avenue and Patton Street in Detroit, less than half a mile from where victim 1 had been assaulted. Victim 2 reported that the assailant had used a condom. Page 2. 4, a used condom was collected at the scene of the sexual assault of victim 2, and biological material was swabbed from inside and outside the condom. Samples were submitted to Relogenate Laboratory for testing, including DNA analysis. 5, police arrested Terrence Calhoun based on a composite sketch created from the description given by victim 2. 6, for the victim 2 assault, Mr. Calhoun was charged with first-degree criminal sexual conduct involving a weapon, kidnapping, assault with intent to commit sexual penetration, and felony firearm. See case number 06-013904-01-FC. 7, for the victim 1 assault, Mr. Calhoun was charged with kidnapping and assault with intent to commit sexual penetration. See case number 06-013905-01-FC. And I should have asked your court reporter, am I going too fast?
No, you're not, but since we have a break and while it's on my mind, I want to go back to line 4 and spell the name of the laboratory for her because I know that she looked up to me seeking that spelling. It is RELIA, same word, but a capital GEE. But I think you're going okay. I haven't, okay, she's got her hand up in a wait a minute sign.
I did want to ask, when she began reading, the very beginning, she said the date of 9 and then it blinked out something. Was it 9/6, 9/7?
Are you talking about paragraph 1 on September 26,
She said September 26?
2006?
Okay.
Any other questions?
No, thank you, Judge.
Okay, I can tell usually when she needs something and I caught this spelling. She has followed along without indication to me, but if you wouldn't mind a slower pace, Ms. Newman, I think it's simpler for her, easier to transcribe.
Absolutely, Your Honor.
Hold on just a second. Ms. Newman, I got another request from my stenographer.
She just needs to know that the sound is blinking on and off a little bit.
Okay, and you know what, Ms. Newman, you can see that my legal staff just came into the courtroom. We have handed to her what you are reading from, and I would note that you have read it so far verbatim. I think that will assist as well.
Okay. Very good. Then we're on to number 8.
All right,
In
so let her
connect-
get- she's moving that paper. Are you good?
Ready, Judge, thank you.
Go on.
All right, number 8. In connection with both cases, there were 2 orders for a forensic examination dated December 8th, 2006 and January 29th, 2007. A report by the Center for Forensic Psychiatry was issued February 21, 2007, which indicated that Mr. Calhoun has cognitive deficiencies, but was legally competent to waive his constitutional rights and stand trial. Number 9, on February 21st, 2007, Mr. Calhoun entered pleas of no contest to attempted kidnapping in case number 06-013905 2-01-FC involving victim 1 and to first-degree CSC kidnapping and felony firearm in case number 06-013904-FC involving victim 2. Number 10, on March 28th, 2007, Mr. Calhoun was sentenced in case number 06-013905-FC to a prison term of 11 months to 5 years, and in case number 06-013904-FC to 15 to 30 years in prison for the first degree CSC conviction and the kidnapping conviction, consecutive to a 2-year sentence for the felony firearm count. Number 11, Mr. Calhoun was appointed counsel for the purpose of pursuing appeals or post-conviction remedies in both cases. Number 12, on June 15th, 2007, short tandem repeat and in parentheses STR analysis was completed on the condom collected at the scene of the sexual assault on victim 2. That analysis excluded Mr. Calhoun as a donor of biological material. Number 13, on September 10, 2007, Mr. Calhoun, after consulting with his appellate attorney, dismissed his appeal. There is no indication that the results of the STR analysis completed on June 15th, 2007 were provided to Mr. Calhoun's appellate counsel. Number 14, in January 2019, as part of the sexual assault kit and in parentheses SAK protocol, a SAK assistant prosecutor reviewed Mr. Calhoun's case. Based on the 2007 lab reports, SAK notified the State Appellate Defender Office, in parentheses SADO, of Calhoun's exclusionary test results on January 14, 2019. 15, on February 2nd, 2019, the Honorable Prentice Edwards Jr. appointed the State Appellate Defender Office to represent Mr. Calhoun as part of SADO's rape kit screening and DNA testing project. Page 3, number 16, SADO subsequently arranged for Bodie Technology to conduct additional STR analysis of the condom from the victim 2 sexual assault. 17, on August 14, 2019, and on September 2nd, 2019, Bodie Technology confirmed the earlier report completed in 2007 by Reliagene Laboratory and concluded that Mr. Calhoun was not the donor of biological material recovered from the condom collected at the scene of the victim 2 assault. Number 18, on January 10th, 2022, the Michigan State Police reported that a CODIS report had matched the DNA recovered in the victim 2 assault to another individual who is currently charged with other sexual assault offenses in the Detroit area that are alleged to have occurred between 2007 and 2014. Victim 1 described her assailant as having braids and a puzzle tattoo on his arm. Mr. Calhoun had neither braided hair nor a puzzle tattoo. During the post-conviction investigation, the Wayne County Prosecutor's Office Conviction Integrity Unit conducted a national search of law enforcement databases. The search turned up only one individual with a puzzle tattoo on his arm. That individual is currently incarcerated in the Michigan Department of Corrections for sexual assault convictions. 22, since June 15, 2007, Mr. Calhoun has been excluded as the donor of the DNA recovered from the condom found at the scene of victim 2's assault. There is no indication that the evidence was provided to the defense prior to 2019. Subsequent testing not only confirmed Mr. Calhoun's exclusion, but also revealed a match with another individual who is currently charged in multiple sexual assaults in Wayne County. 23. Additionally, victim 1 described an assailant who definitively cannot be Mr. Calhoun. 24. Considering these facts, the parties hereby stipulate that Terrence Calhoun's convictions and sentences in cases number 06013-904 FC and number 06013-905-01 FC be vacated and both cases dismissed with prejudice. It's dated today's date, April 27, 2022, and signed by myself, Michael Middlestat, and David Williams. There's an additional document that's just the order. Did you want me to read that into the record as well, Your Honor?
No, but I do want to say something. At the conclusion of reading paragraph identified as 24, you left out CMCL 770.
Oh. I did. Thank you for catching that, Your Honor.
Okay, and I would note that the document was read verbatim by Ms. Newman. This is the document that the court has in its hand and received today. And there's electronic signatures of Valerie Newman, Michael Middlestat, and David R. Williams. I do have the order, and I'm happy to read that into evidence at the end of the hearing if that's acceptable to everybody. Okay with you, Ms. Newman?
Okay with me, Your Honor.
Mr. Middlestat?
That's fine, Your Honor. Thank you.
I would also, well, let me get to that in a moment. I would go back to you, Ms. Newman, because you said prior to the court asking if the prosecution could articulate for the record the findings that support the people's decision to vacate Mr. Calhoun's conviction and sentence, you had commented that you wanted to say something, and I'm offering you that opportunity at this time.
I appreciate that, Your Honor. So I want to be clear because of what happened last time. I appreciate you, Judge, starting the hearing by asking about the information that had been provided. But I want to make sure that from the prosecutor's office that I am being fully transparent with the court and with the public, because I think what happened raised the specter that somebody might, could infer that maybe we were trying to hide something. So I don't know if this can be captured, but I just want to show it for the camera. This is exactly what was given to me that had been, that the officer tried to give to you, Judge. So it's a manila envelope. On the front of the manila envelope, it says Defendant Calhoun Terrence. Gives some information. It has a command file number, a warrant number, officer in charge of the case, Jose Ortiz, and gives the complainant's name that an address, which I'm not going to put on the record, a charge and some other information on the front of this file. Contained in this manila envelope is the original police file from victim 2's case. And so I just want to tell the court that not only have I reviewed it, but my detective reviewed it. Another member of my staff reviewed it. We all compared it to the police file that we already had in this unit, and it is identical. I will also note for the record that what is not contained in this file is the June 15th, 2007 report from Relagene indicating that Mr. Calhoun was excluded as the donor to the material on a condom that had been tested. So I just want to make sure and that I had informed the defense as soon as I reviewed the file. I got in contact with all the defense attorneys and let them know that this file was a file that has already been turned over to them. And that everyone already had in their possession. So that's, I just want to be crystal clear on that point. I also want to, I want to thank the court for being forthright last week. It's always good to, double check what's going on. It never hurts the process to shine more of a light on things. And so, we had the opportunity to do that, but I also don't want to lose sight of the fact that really today is about the myriad of things that went wrong that caused the wrongful conviction of an innocent person. There's so many things that happened in this case that are troubling. And while this is ostensibly a DNA exclusion case, there is a lot more going on here that supports Mr. Calhoun's innocence than just the exclusion from the condom. We have the fact that one of the victims gave a description of her attacker that could not be Mr. Calhoun. And so there were so many things that were missed along the way in terms of this investigation, that while we're not relying on those things to say to the court, this is why you should vacate the convictions, I think it's important for the court to know that there are a myriad of things in addition to what's in the stipulation that support the fact that Mr. Calhoun is innocent of both of these the attempted sexual assault and the completed sexual assault. Furthermore, when we did the victim notification, one victim we were unable to locate, so we were not able to speak with her. But the victim of the completed sexual assault, we were able to locate. We spoke with her and her guardian, and the response when we laid out all the information like we've laid out today in the court and other information that we have that goes to his innocence, the response from her guardian is, I hope you're going to get that man out of prison as quickly as possible. So, the victim, at least the victim that we spoke to, is completely on board with everything that's going on here today. We offered them the opportunity to come to court to speak, and they declined to do so. But I think that's an important piece of this, especially from anyone in the public who's watching this, to know that as part of the CIU process, we have a very, very intense and thorough process that we undergo when we pick up a case. And we interview people, we look at the police files, we look at all the original evidence, we look at the new evidence, we evaluate the new evidence, and then we come to a determination after we've done, a really intensive investigation. These are not decisions that we make lightly. I don't make any recommendations to Prosecutor Worthy lightly. I understand as the head of the Conviction Integrity Unit that I know not only have an obligation to this office and this community, but to every Conviction Integrity Unit across the country. Because if we make a mistake, it undermines this mission for everybody, not just for the people in Wayne County. So we undertake this with great gravity and full understanding of what it means to come to this court and say, Judge, a mistake has been made. This is everything that supports it. And this is why we're asking you, to take these actions. I also want to highlight just a couple of things, which is one, I want to thank Chief White of the Detroit Police Department, who came out with a very strong statement condoning what this officer did in this case, as well as Chief Judge Kenny, and as well as the court for bringing it to light, because this is the only way the system can work. If we're transparent and we disclose and we deal with things out in the open. So I do want to say, that I appreciate how everyone has quickly, condemned this officer's actions of trying to do something and hide this in the dark and do something surreptitious. And I also just want to emphasize how troubling this case is, that the CODIS hit on the condom came back to someone who is now charged with multiple sexual assaults. It highlights the fact that when the police get it wrong and we lock up the wrong person, it leaves the true perpetrator on the street free and clear to continue to commit more crimes. So doing the work that the Conviction Integrity Unit does is vital to the community. It's not only vital to the individual like Mr. Calhoun, who's been wrongfully convicted and sat in prison for the last 15 years for a crime he didn't commit. But it's vital to the community, because if these cases, if the wrong person just keeps getting blamed for something, then the real person gets to stay out there, and it creates, it's a safety issue for our community. So I really, I'm very thankful to Prosecutor Worthy that she has the courage to have formed this unit and to support this unit, and for us to be able to do this really very, very critical and important work that helps keep the community safe. It protects the integrity of the justice system by having a safety valve that people can come to us if they're claiming a wrongful conviction, and that we have a court that was, in yourself, Judge Ramsey, that was judicious and careful and forthcoming about everything that's happened in this case. And with that, I just ask that you sign the order and grant the relief requested.
Ms. Newman, for clarity, I just want to ask you one question because I wasn't certain. You identify in the stipulated findings of fact, victim 1 and victim 2.
Correct.
In your statement to the court, you indicated that you were unable to find one of the victims, and then you did have conversation with the other. What victim did you have conversation with, victim 1 or 2?
2, victim 2.
I didn't follow that, and I just wanted that to be clarified.
Sure, thank you, Judge.
All right, and just in response to your statement about the circumstances of last week, it was certainly the court's intent to ensure that there was an opportunity for due diligence, and the court must ensure that justice is done, and simply gave an opportunity for a second look. And thank you to everybody for your patience, understanding, and the additional efforts that went forward since we were all here last week. Mr. Middlestad, I'd like to ask you, one, if there is any further comments that you would like to place on the record today, and second, whether or not Mr. Calhoun wishes to address the court, and how you'd like to proceed, I'll leave in your hands, sir.
Yeah, just briefly on behalf of myself and Mr. Calhoun, I would like to thank the Wayne County Prosecutor's Office Conviction Integrity Unit and Prosecutor Worthy for putting so much work with us in on this case. This has been a painfully slow process for us and for Mr. Calhoun, but we understand, as Ms. Newman just explained, that there needs to be competence in a decision like this, and that much due diligence is needed so that no stone is unturned to make sure that we have the facts right. And we appreciate that they took the time not only to hear us out and to do the independent investigation that was necessary, but also to look into the new information. I share a lot of what Ms. Newman has said about the various flags that are present in this case. Many of these flags we see often with wrongful convictions and in exoneration cases. I would also say too that it is very concerning that DNA evidence that excluded Mr. Calhoun did not make it into the defense's hands. That is a very concerning development, and there have been ethical rules and whatnot that have been changed in light of things like this happening to prevent things like this happening since 2007. In my opinion, there is a cloud over this investigation. And what Mr. Kane did last week was more befitting of a vigilante than that of a public servant. And what he did only darkened that cloud. It did nothing to remove that cloud. And I appreciate the fact that the information was turned over to us and to the prosecutor. And it is clear to me that no new information was brought to the table, and that Officer Kane was just making one final plea to preserve this conviction. But again, I thank the court, and I thank Ms. Newman and the Detroit Police Department, and would ask that Your Honor accept the stipulation in order and release Mr. Calhoun immediately.
Mr. Middlestad, thank you for your comments. Does Mr. Calhoun wish to say anything?
Can I put you on mute just for a second, your judge, and talk to Mr. Calhoun to see if he would like to say something?
Absolutely. Take the time that you need. We're going to go pause off the record.
Terrence, would you like to speak, or you don't have to
No,
if you
we
don't?
can still hear you. Hold on a second. We can still hear you and we're live on YouTube, so you
I
need to
muted.
mute yourself.
I muted them.
We did it on our end. I think you can still hear us. We did it on our end, and I'm gonna formally go off the record.
He needs to unmute.
Is he back? Okay.
Judge, we are back, Judge. I don't know if you need to go back on the record.
Oops, what did you just say? I am back on the record.
Okay, thank you, Judge. We're back. I understand we're back on the record. I have spoken to Mr. Calhoun, and he is determined that he does not wish to speak at this time. My co-counsel in this matter, Tabitha Harris, would like to bring a motion, but I'm not sure if it should be done now or after the court makes a ruling on our proposed stipulation.
Well, I'm gonna get there in just a second. I do recognize that, it's Tabitha Harris, correct?
That's correct, Your Honor.
All right, and Mr. Williams, you are from the Cooley Innocence Project. Anything from you, Mr. Williams?
No, Your Honor.
All right, and Ms. Harris, let me hear your motion at this time, please.
Yes, Your Honor, thank you. We would like to ask that the court sign an order regarding the destruction of biometric data and arrest records with the Michigan State Police, Your Honor, and we would make that motion if Your Honor does grant the motion for Mr. Calhoun, the vacation of Mr. Calhoun's charges. Your Honor, as you're aware, Mr. Calhoun is going to be residing with his family out of state. They're going to be taking him, if Your Honor grants the motion, they will be taking him out of state to reside with them. And this would be expedient, Your Honor, and they would be able to handle this while they're here in the state of Michigan. Thank you.
Okay. All right, I'm gonna get to the destruction of the biometric data and the arrest records following a ruling on the motion. Anything else from any party?
No, Your Honor, not from the people.
All right, the court has both read prior to this hearing as well as certainly placed on the record the stipulated findings of fact and agreed upon order to vacate the conviction and dismiss these cases with prejudice. And the court is also in receipt of an order that was presented to the court indicating that a session of the court held today on April 27th, 2022 before myself, that the matter has come to the court based upon the party stipulation by the findings of fact that were read into the record, and the court otherwise being fully advised regarding this matter. The court is going to grant the motion and hereby order that the convictions and the sentences in the above captioned matters be vacated. I would indicate that that is Circuit Court number 060139 04-01FC and Circuit Court number 06-13905-01FC. It is further ordered that all of the charges in the above captioned matter are dismissed with prejudice, and the court is signing the document that has been presented to the court. Regarding Ms. Harris, your motion, I was also presented two orders, and this is on two different pages, identifying separately case number 06-13904-01 and 06-13905-01. These are orders that reference different charges. So I think I'm going to go back and do this separately, starting with 13904-01. It indicates count 1, criminal sexual conduct in the first degree, count 2, kidnapping, count 3, felony firearm. The MCL PAC code is identified, indicating that Terrence Turnell Calhoun has filed a motion requesting that his biometric data and arrest record be destroyed by the arresting agency of Michigan State Police as required by law. At the hearing in front of myself, it's marked that the court is going to order an immediate destruction of the biometric data and arrest record of the defendant, Terrence Turnell Calhoun, and provide certification to that fact. And the court is going to sign and date this matter with by bar number P39321. The second page reference the second file 0613900501. These are forms MC 392. The forms are identical in nature. And on the case ending in 905, there is count 1 kidnapping attempt. It reads identically. And yes, the court is going to grant the request and destroy the biometric data and the record in the arrest record of the defendant, Mr. Calhoun. And I think I heard you say, Ms. Newman, that you are in the office and you can certainly get copies of the court's orders momentarily.
All right, I'll come down to the courtroom, Judge. Thank you very much. And then you'll send that right to the MDOC so they can start processing the, or Brantwell.
Today, and they are well aware of the urgency of the matter, and we'll ask them to take the time and do so immediately. It will be out of our hands by the close of business today.
Thank you, Judge. We appreciate it.
Anyway. All right, Mr. Calhoun, good luck to you. On behalf of the Wayne County Circuit Court and myself, I apologize for the delay, and I hope that you understand that the court's intent was to ensure that justice is done, and my very best to you, sir.
Thank you.
Else, you're welcome, Mr. Calhoun. Seek the best in yourself every day, Mr. Calhoun.
All right.
Thank you, Your Honor.
Thank you, Your Honor.